Well, a Canadian farmer is being ordered to pay more than $60,000 following confusion over a thumbs up emoji text that he sent in response to a flax buying contract. Roger McEowen with the Washburn School of Law joins us now for more on this matter. Roger, this is mind-boggling. Walk us through the situation and the court's ruling on this.
Actually, Suzanne, good to be with you. That's what's going to happen in the United States, too, based on the facts of this case. But what happened here is that you had a grain terminal that sent a text message to a group of farmers offering to buy flax for $17 a bushel for delivery later in the year. So it's your standard forward grain contract situation. And then they followed that up with phone conversations with a farmer that was interested in selling his flax for $17 per bushel and sent them a contract for $17 a bushel for November delivery. And the terminal representative signed that contract in ink and then sent a photo of the contract by text message to the farmer asking for confirmation. And the farmer sent a text message back with a thumbs up emoji. And when time came for delivery in the fall, guess what had happened? The price of flax tripled. It went to $41 per bushel. And of course, now he wants out of the contract because he wants to sell it for $41 per bushel to somebody else, not $17 a bushel under this purported contract. And he claimed the emoji was, well, all I'm doing is signifying that I got the contract. I'm not signifying that I'm agreeing to it, that I didn't accept your offer. But the court didn't buy that. The key issue is not what he believed. The key issue is what the seller reasonably believed that the buyer, what the buyer reasonably believed that the seller was thinking when he sent that emoji. And so on that basis, the court said it was clear enough. There was offer and acceptance to the essential terms. That equals a contract. And so in the law, we say that's objective manifestation of intent. And the farmer also, the court said, hey, you've done this 4 other times. No, you didn't send an emoji, but you said, okay, by text message, or you said, yep, or you indicated by text message that the contract was fine. And the court said, well, based on what you've done previously, this is a contract. And the buyer objectively and reasonably believed that you were serious. And so the deal's done. You can't back out.
So it's not just by this thumbs up emoji. There was some conversation prior to this as well. But what about just having a signature on the contract? I mean, doesn't that have to come into play?
No, digital now, the states, and in fact, in Kansas, we have a digital contract statute. Digital is good enough as signature. And that's the way that things are going. And people have to realize that. And just about all states recognize that a digital signature is enough, or a digital recognition of a contract is enough. And an emoji will get you there coupled with these other facts.
Wow. Similar case I want to bring up, 1950s. I understand there was a producer that ended up selling his farm because of a note that he wrote on a restaurant check.
Yeah, there was a Virginia case, went to the Virginia Supreme Court in 1954, and basically what it was 2 drunks on Christmas Eve that were bluffing over the sale of a farm, trying to bluff each other, and the guy that owned the farm thought that this other fellow didn't have the money for a down payment, and so to call his bluff, he scribbled out a paragraph on the back of a restaurant check, took it up to the cashier, which was his wife, said, sign this, we need to get him out of here. So his wife signs it. And the guy gives him the down payment, and he said, well, convey the farm to me now for $5,000. And this wasn't just 10 or 20 acres. And the court said, yeah, that's a contract, because he reasonably believed that the conversation was serious, even though the seller tried to say, well, hey, we were just, as the court said, 2 guys high as a Georgia pine. And the court said, no, manifestation of intent to the core contract terms. You've got a binding contract. You've got an offer. You've got acceptance.
Manifestation of intent. That is the big thing, and that makes it legally binding. So everybody watching right now is going, wait a sec, I'm going to withdraw that text I just sent. Talk about what farmers and ranchers need to keep in mind when doing this, and whether an adult beverage is involved or not.
That's right. It's real easy to form a contract based on circumstances in some instances. And it's good to remember that digital is the same as pen and ink. And that's just the way things are. We've got to keep that in mind. And as to grain trades, all you need under the grain trading rules is any form of confirmation. And so on forward grain contracts, you're going to bear the risk that the price of that commodity is going to be higher at delivery than the contract price. So be very careful. All it takes is what the buyer reasonably believes that you were doing whenever you did what you did. If we've got an offer and an acceptance, core meeting of the minds under the core concept, core contract concepts, we've got a deal. So be careful.
So interesting. Roger, thank you so much for joining us. Boy, interesting stuff for sure. A lot of people are going to be second guessing when they sit down and doing the right thing. Roger McEowen with the Washburn School of Law. Appreciate you.